New York Real Estate Broker Exam. Let's get started. A property owner in Albany discovers that their neighbor has been using a portion of their land for parking without permission for over 10 years and now claims ownership through continuous use. Under New York legal issues in real estate, what doctrine might apply here? Is it A, eminent domain? Or B, adverse possession? Could it be C, encroachment? Or lastly, D, variance? The correct answer is B. Here is why. Adverse possession is the doctrine by which a party may acquire title to real property through open, notorious, continuous, hostile, and actual possession for the statutory period, 10 years in New York. Option B is correct. Option A is incorrect. Eminent domain is government takings. Option C is incorrect. Encroachment is an unauthorized intrusion but does not transfer title. Option D is incorrect. A variance is zoning relief. Next question. In Albany, a salesperson advises a client on personal safety during showings, recommending buddy systems. This relates to what New York topic? Is it A, licensee safety? Or B, fair housing? Could it be C, agency disclosure? Or lastly, D, environmental issues? The correct answer is A. Here is why. Real estate licensees face risks during showings and open houses. Safety practices such as buddy systems, informing others of location, and maintaining situational awareness are part of licensee safety education. Option A is correct. Options B, C, and D are unrelated to personal safety. Next question. In a dispute over a shared driveway in Buffalo, two adjacent property owners argue about maintenance responsibilities. The driveway was established by a written agreement 20 years ago, but was never recorded. Is this easement valid under New York law? Is it A, yes, as long as it's in writing? Or B, no, because it wasn't recorded? Could it be C, yes, if it's an easement by prescription? Or lastly, D, no, unless both parties agree now? The correct answer is A. Here is why. An easement created by a written agreement is valid between the parties regardless of recording. Recording provides constructive notice to subsequent purchasers, but is not required for creation. Option A is correct. Option B is incorrect. Recording is not a condition precedent to validity. Option C is incorrect. The easement exists by express grant, not prescription. Option D is incorrect. The existing written agreement is binding. Next question. In Queens, New York, a real estate broker is accused by a client of failing to disclose a known material defect in a property's foundation during a transaction. The client files a complaint with the New York Department of State. Under license law, what standard must the broker adhere to regarding disclosures? Is it A, disclose only if asked directly by the buyer? Or B, full disclosure of all known material facts to all parties? Could it be C, disclosure only to the buyer, not the seller? Or lastly, D, no disclosure required if the defect is not visible? The correct answer is B. Here is why. New York license law and agency principles require full disclosure of known material facts affecting property value or safety. The doctrine of caveat emptor does not excuse active concealment or failure to disclose known defects. Option B is correct. Option A is incorrect. Disclosure is mandatory regardless of inquiry. Option C is incorrect. Agents owe duties to their clients, but material facts must be disclosed appropriately. Option D is incorrect. Known defects must be disclosed even if not visible. Next question. A licensed real estate broker in Buffalo, New York, employs several salespersons and decides to pay a referral fee to an unlicensed individual who provided a lead that resulted in a successful property sale. The broker believes this is acceptable as long as the fee is not considered a commission split. Under New York Department of State regulations governing real estate licenses, is this action permissible? Is it A, yes, as long as the referral fee is documented in the closing statement? Or B, no, because only licensed individuals can receive compensation for real estate activities? Could it be C, yes, if the unlicensed individual is a family member of the broker? Or lastly, D, no, unless the referral fee is less than 1% of the sale price? The correct answer is B. Here is why. New York Real Property Law Article 12A strictly prohibits paying compensation for real estate brokerage activities to unlicensed persons. Referral fees for leads that result in a sale constitute compensation for activities requiring a license. Option B is correct. Option A is incorrect. Documentation does not legalize an unlawful payment. Option C is incorrect. Familial relationship does not exempt the unlicensed individual from licensing requirements. Option D is incorrect. No de minimis exception exists for referral fees to unlicensed persons. Next question. During negotiations for a single-family home sale in Albany, the buyer includes a mortgage contingency clause allowing them to cancel if they cannot secure financing at no more than 5% interest within 45 days. The seller counters by removing the contingency entirely. The buyer refuses and the transaction stalls. Under New York contract law principles, what best describes the status of this contingency? Is it A, it is non-essential and can be removed unilaterally by the seller? Or B, it is a material term that protects the buyer and mutual agreement is required to remove or modify it? Could it be C, mortgage contingencies are prohibited in New York residential contracts? Or lastly, D, the contingency automatically expires after 30 days regardless of terms? The correct answer is B. Here is why. Mortgage contingency clauses are material terms of a real estate contract. Modification or removal requires mutual agreement of the parties. The seller's counteroffer attempting to remove the contingency was rejected, so the original offer with the contingency remains. Option B is correct. Option A is incorrect. Material terms cannot be unilaterally removed. Option C is incorrect. Mortgage contingencies are standard and permitted. Option D is incorrect. The agreed 45-day term controls. That's it for today. How many did you score? Let me know in the comments. Please like and subscribe, and tell me what topic I should cover next. Bye.